Good morning, everyone. My name is Michelle Maloney from the Australian Earth Laws Alliance. I am in partnership with Lisa Mead, presenting today the second part of the Earth Rights session for the PPT. So I hope you can see my slides. Excellent. So my name's Michelle Maloney, and as I said, Lisa Mead will be joining me. She's on the call now. She'll be joining us for this session. So just a brief introduction, just so that you know my qualifications. I've got a Bachelor of Arts and Bachelor of Law with honours from the Australian National University and a PhD in law. I'm also the co-founder of the Australian Earth Laws Alliance and have been working on rights of nature, earth jurisprudence and ecological governance issues for about 7 years, on top of 20 years before that on environmental law and sustainability issues. My organisation is the Australian Earth Laws Alliance, or AILA, and our mission is very simple: to increase the understanding and practical implementation of earth-centred governance. And by that we mean law, economics, ethics, culture. And that diagram at the bottom shows that we focus on a change in culture in industrial societies, as well as reconnecting law and governance with the nature and the matters of the issue, the issues that matter, building community, creating alternatives, and then transforming law and governance. Just having a bit of trouble with my button. There we go. So an overview of our session today. We hope to complete our session in the time allotted, 2 hours. We may try to go a little shorter than that because we've started a little later. I'll do a bit of an introduction and a recap on Lisa's excellent session earlier this week. And then I'll give an overview of some of the emerging laws around the world that recognise and support the rights of nature. We feel that this is a really important context for the PPT to understand why this emerging space around recognising the legal rights of the natural world is relevant to a case that's challenging the impact of unconventional oil and gas extraction. We'll then invite an expert witness, Murray Margle. We'll have a video footage from another expert witness, Damien Ma, who I'll introduce as we bring them all on. Lisa will actually speak to a bit of evidence about fracking's impacts on earthquakes and seismic activity. We'll then turn to our final video for the session, which looks at the way that people in Scotland have addressed fracking and their choice to issue a moratorium, and then we'll do our closing statements. So just to recap on Lisa Mead's session, Lisa introduced our overall argument, and she also talked about the Universal Declaration for the Rights of Mother Earth and how it's a civil society agreement formed in 2010 by more than 30,000 people, which holds extreme moral weight and an emerging law and statement of principle around the fact that we are an interconnected, indivisible community of life, that industrial legal systems do not at the moment reflect the fact that we rely on and are interdependent with the natural world. And in fact, the UDRME is an important basis for our entire case here at the PPT because it offers a statement, a normative statement of how our legal systems should be. And interestingly, since it was created in 2010, which I'll talk about in a moment, quite an upsurge of laws around the world that are starting to reflect those very principles and this shifting norm towards recognising the rights of nature in our legal system. So Lisa talked about the UDRME and outlined the rights of nature. We also heard from expert Cormac Cullinan and Linda Sheehan. We also heard evidence from Michelle Bamberger and Dr. David Paul of violations of the fundamental rights of plants and animals to exist, thrive and evolve, and the fact that fracking and CSG has been violating the rights of life to exist, thrive and evolve. Lisa also showed evidence in a video witness from Professor Gavin Mudd from here in Australia, talking about the impacts of fracking on waterways. So what I will do now is actually talk through some of the emerging rights of nature laws around the world. Again, just to give you some context. I will do it fairly quickly and I'm very happy to take questions. I just wanted to give quite a growing number of examples of how rights of nature is working around the world. This is a brief summary and then I'll have a couple of extra slides on a couple of these points. So in 2002, CELDEF, and I'm very honoured to have Murray Margle from CELDEF on our session today. CELDEF began a push for local laws to pass rights of nature and community rights laws in the US, and she'll talk about that in her presentation. In 2008, Ecuador was the first modern constitution in the world, by modern I mean Western legal structure, to actually recognise the rights of nature in its constitution. In 2010, Bolivia implemented a national law. In 2010, Bolivia also hosted this phenomenal gathering looking at climate change and the rights of Mother Earth, and everybody worked together to create the UDRME. Since 2016, activists and lawyers in Europe have been pushing for an EU directive for the rights of nature in the European Union. In 2016, interestingly, not a legal structure but a policy development, the Greens Party of Scotland and separate Greens Party of England and Wales both adopted rights of nature policies. 2017 was somewhat of a push forward for rights of nature and legal personhood around the world and attracted significant attention internationally. And I'll talk in a moment about what happened with New Zealand, India, and Colombia. There's also a lot of social movements around the world, as well as the work of the Global Alliance for the Rights of Nature, all of which are bringing people together who are trying to force through a shift in the legal system and also represent what people know in their heart to be true, that we are completely dependent and part of the natural world, and our legal system should no longer treat it as invisible, but an equal player in, not an equal player, the most important player in our society and our legal system. Very briefly, just for those who aren't familiar with it, the current framing of rights of nature, many people look to the work of Thomas Berry. He's written a number of books. He called for earth rights. It does build on a longer history of deep ecology and legal writing, everything from Christopher Stone's Should Trees Have Standing, etc. There's quite a phenomenal body of work that we can turn to. But I just wanted to mention that the theoretical framework many of us use for rights of nature comes from some of the ideas articulated really beautifully by Thomas Berry. Any future governance system must recognise the rights of the non-human world to exist, thrive, evolve, and generate. Berry looked to First Nations culture and law, as we all do, for deep inspiration for how earth-centred governance and law can work and how it can permeate and infiltrate the living culture of a human society. It's really important. But Berry also gave us a gift by challenging the Western legal system to actually look at this more seriously and to activate it. But the other point that I would mention in amongst this amazing body of work that I could honestly talk about for days, rights of nature is a little distinct to legal personhood, because rights of nature articulates that rights exist where life and life-supporting systems exist. And nature has its own rights. It doesn't have to have human rights. Bees have bee rights, rivers have river rights. And these rights, or these arguments about how it should be maintained and left to exist, are really just based on the way that these natural systems, animals and plants, work and live and operate. Final point on Berry is that he always said that we're a community of subjects, not a collection of objects, and that's a fundamental point for the whole Earth Laws movement. In a moment, when I talk a bit more about New Zealand, India and Colombia, I'll talk a little bit about legal personhood for nature, but I won't go into too much detail. There's a lot of material for those who would like to read about it. The main point I would like to make is that legal personhood and legal rights for nature is an emerging legal space. But when we talk about legal personhood, we're of course talking about really taking the first step towards rights of nature. In our analysis, at least within the Australian Earth Laws Alliance, we see a bit of a difference. Sometimes in practice it's not hugely important, but there is a difference in stating that something has legal personhood rights, i.e. the same recognition as something like a corporation, which is treated in law as a legal person, even though it's not a human being. And the difference is with legal personhood, and we'll see this in the India case, there's been a little bit of confusion for some people in how you articulate the rights of nature when you talk about it in literally a human-centred way, legal personhood. We believe that Thomas Berry's articulation of bees having bee rights, the whole argument for rights of nature, is that the intricate, unique system of life has its own unique rights. But that said, I won't go any further about this, but what's important about the legal personhood space is that it's been a really, it's an area that's developing quickly. Last year we saw this with the progression of a number of laws, because it's a way for the Western legal system to grab a concept that it already understands, i.e. corporations and other entities have legal rights, legal personhood rights, and moving forward with that with nature. So it's offering up some very interesting analysis. Very quickly though, Ecuador in 2008 included these provisions, and it's what I would say, it articulates a rights of nature framework, not a legal personhood framework. It talks about the interconnectedness and vitality of life, the indivisible nature of life, the primacy of earth laws, and so on. There's been a number of successful cases argued under the rights of nature provisions in Ecuador, including the rather famous Vicabamba River case in 2011 that found for the rights of the river to flow, and other cases. In Bolivia, the national law is again very much focused on the rights of nature, does not talk about legal personhood. I just want to briefly show a photo of the Universal Declaration for the Rights of Mother Earth, the UDRME. For those who don't know, it was held over more than a week, and the thousands and thousands of people were genuinely engaged in crafting and writing up the documents, and Cormac Cullen and many other people were involved in that process. Very quickly again, in New Zealand, in 2017, an act was passed in Parliament by the New Zealand government that was the result of decades worth of discussion and compensation arguments between the Maori people and the New Zealand government under the Treaty of Waitangi. I can provide more info on this if you want it, but just to move through the slides quickly, what's important about the Whanganui River is that was the first time in a Western sort of colonised nation that Indigenous values and the recognition of this living entity as a whole were embedded into a modern legislative tool. It took the debate between Maori people who wanted not just compensation, but to be returned to their spirits and their land, and the Crown's resistance to that argument. And it allowed somewhat of a halfway house by using Western tools and articulating that the river has its own legal identity, and it's got two guardians, one from the Crown and one from the Maori Trust, as a setup to take away the previous arrangement where it was just the ownership of the Crown. A broader guardianship structure was set up at the end of last year. And the reason I talk a little bit about Whanganui River is it is the one that has inspired references from courts in the court cases in India and Colombia. Some people don't know that in New Zealand there are now 3 major ecosystems that have their own legal rights. The Urewara Forest is very interesting. Again, after many years of debate and discussion and arguments, the Waitangi Treaty discussion process, legal decision process, came to a new act that came out in 2017 where the Tua Urewara will effectively own itself in perpetuity. And then at the end of last year, and I'm still to do some reading on how the structure will work, Mount Taranaki also has these same legal rights as a person. So New Zealand has been leading the way in the legal personhood developments. So interestingly, on top of all of the many years of the developments under the Treaty of Waitangi, in early 2017, we saw two court cases pop up in India that were really important and grabbed international attention. The state of Uttar, I'm not even going to try to say that at 6 o'clock in the morning. In India, the court decided that the rivers Ganga and Yamuna and all their tributaries, streams, every natural waterway flowing are declared as a legal person and would have the status of a legal person with all the corresponding rights. There's a whole range of issues that have have been developing around people challenging that decision by the court, undergoing scrutiny, particularly around the idea of nature having liabilities. But the fact that this case has come into a jurisdiction that does not have a legislative basis for the rights of nature is extremely important and very powerful. As same with Colombia in 2017, again, in that first 4 months of last year, we saw all of these river cases coming out. A court in Colombia recognized the Atrato River, together with its basin and tributaries, as a legal entity. And the river's rights are distinct from the community's rights, and its rights are to protection, conservation, maintenance, and restoration by the state and local communities. And then earlier this year, it went further, and now the Amazon region inside Colombia has been recognised as having legal rights. It's the first time that a bioregion or a sub-region has legal rights. Just wanted to briefly mention, in Australia last year, there's been a new act for the Yarra River, which does not give legal rights to the river, but it does, for the first time in Australia's sordid colonial history, recognise the Indigenous people's connection and spiritual connection to the river. It's an interesting development and one that many other communities are looking to. They're looking at that and connecting it with rights of nature, seeing what can happen in Australia. And we had our first public rally for river rights in Australia in March in Western Australia. So what I wanted to say from that material was really simply that we see this emerging social and legal norm shift as really changing the way that people are looking at the legal system. It's a way for ecological governance and democracy to be shifted so that local communities particularly, but the broader Earth community, can argue for greater standing, enforcement and rights for natural systems. The increasing body of law demonstrates that it's a shifting norm, demonstrates that people want a different system. Excuse me. And increasingly it demonstrates civil society will not tolerate damage to ecosystems. And finally, we have put into our written submission that we think this growing jurisprudence, which articulates rights of nature and how they can be enforced, is actually shifting what we think is towards a growing evidence of a customary international law for the rights of nature. Excuse me. I don't even have any water. I'm not going to talk to these notes, but I just want to flag for the tribunal that there are many issues around rights of nature, including how do you speak for nature. It's about relationships, about establishing the rights and duties. It can change standing in a legal jurisdiction. It already has in those places where the laws exist. But at the same time, it's also drawing on some very conventional legal tools, remedies such as injunction, compensation, restoration, and the ideas around Indigenous custodianship, community guardianship, new administrative and management structures for the rights of nature. So on the one hand, it has the potential, and it is, to turn the legal system on its head. On the other hand, it can be implemented in such a way that is really no different to setting up a structure to support a company. Another important point to make when we think about the rights of nature within the context of this tribunal, and if people are kind of thinking that how can we give rights to nature, it's important to remember that every time we've expanded rights, there's resistance. From ending slavery in the US, to introducing votes for women around the world, to the constitutional recognition of First Nations people in Australia, people resist what hasn't been there before, and once those laws are passed, they become the norm. I'm going to end my little overview of things with a lovely quote from Mari Margle. It's also a nice segue into her presentation today. An important thing to note is this idea of how could we possibly balance the rights of nature? Well, we believe it's completely easy to do. Recognising rights of nature, as Mari Margle puts it, does not put an end to human activities. Rather, it places them in the context of a healthy relationship, where our actions do not threaten the balance of the system upon which we depend. These laws do not stop all development. They hold only those uses of land that interfere with the very existence and vitality of the ecosystems which depend upon them. And before I introduce Mari, I'd like to draw on this quote to remind the tribunal why Lisa Mead and myself have brought this case and invited these amazing witnesses to join us. We believe that unconventional oil and gas extraction absolutely threatens the balance of the system upon which we depend. The impacts it has on land, the subsoil, plants and animals, particularly and most obviously water and human health, absolutely violate the rights of the natural system, takes out of balance our coexistence with other species, and absolutely should be stopped. So that's the end of my overview of the emerging rights of nature laws around the world. It's now my really great pleasure to introduce Mari Margle from the Community Environmental Legal Defence Fund. She's an attorney based in the US, and together with Thomas Lindsay and others at CELDIF have really been leading the way on rights of nature lawmaking around the world. So without further ado, I'd like to introduce Mari. Mari, would you like to give your presentation?
Thank you so much, Michelle. Can folks hear me all right? Yeah? My name is Mari Margill with the Community Environmental Legal Defense Fund and our International Center for the Rights of Nature. We have based in the United States, but work around the world. In the United States, we've assisted more than 30 communities to establish legal rights of nature and the human right to a healthy environment. This includes many communities that have banned fracking as a violation of the rights of nature. We have also met in 2008 with the Ecuador Constituent Assembly as they were drafting that new constitution there on the rights of nature. And as Michelle said, Ecuador is the first country in the world to recognize legal rights of nature within its national constitution. Today, our organization is working with Michelle in Australia, in the United States, in Nepal, India, and other countries to advance rights of nature legal frameworks. As we see people across the globe finding that legal systems which treat nature as rightless, that is, without even legal rights, basic rights to exist, that they are unable to protect nature. Today, legal systems around the world have split the world into basically two categories. One, either as things or property without legal rights, or as rights-bearing entities with legal rights. Treated as property, we find that nature is considered to be without legal rights. And therefore, environmental laws, which we find around the world, environmental laws authorize the use of property, that is, the use of nature, such as fracking through aquifers, drilling through the oceans, or, as we have in the United States, blowing the tops off of mountains in order to mine coal. Conventional environmental laws, therefore, again, which we find around the world, they legalize fracking, they legalize drilling, they legalize mining and other practices, meaning environmental laws legalize environmental harm. Under decades of these environmental laws, which treat nature as property, which treat nature as being without rights, the state of the environment is worsening. And we see this in many ways, including ecosystem collapse, such as the die-off and bleaching of coral reefs around the world, which support millions of species. And with species, we see species extinction rates around the world occurring at rates that are greater than 1,000 times natural background rates. And of course, with climate change, which is accelerating far faster than even the most optimistic scientific models predicted. The Community Environmental Legal Defense Fund began our work with communities more than 20 years ago to help them protect against environmental harm, including things like drilling and mining. But we ran into this system of environmental law, which legalizes environmental harm, as well as the larger legal system, which Michelle mentioned, which does things like recognizes rights and protections for corporations, including oil and gas corporations and other industries, which draft the very laws which regulate their activities. That is, they're drafting environmental laws which authorize their industrial activities such as fracking and mining. We learned along with our communities that we can't protect nature under environmental laws which authorize its destruction. And with this, in 2006, we assisted the first community in the United States, the very first place in the world, to develop a new kind of law. And that new kind of law recognized legal rights of nature. This was Tamaqua Borough, a small community in the state of Pennsylvania in the United States. Since that time, the Community Environmental Legal Defense Fund has assisted more than 30 communities, which have done the same, recognized legal rights of nature in their local legal system. This includes the city of Pittsburgh in the state of Pennsylvania, a city of 300,000 people or so. It's the first city in the United States to ban fracking as a violation of the rights of nature. We've found that communities have found it necessary to recognize legal rights of nature, including rights such as the right to exist, to thrive, to regenerate, to be restored. To recognize those legal rights of nature alongside the human right to a healthy environment, recognizing that it is impossible to fulfill the human right to a healthy environment if the environment itself doesn't have rights. And for example, with fracking, which contaminates millions of gallons of fresh water at each frack well, which harms human health and the environment, which of course accelerates climate change, we've found it's impossible to fulfill the human right to a healthy environment under legal systems which authorize the use of the environment for fracking. That is, under legal systems which treat the natural world as property, as without rights, and regulate its use to conduct fracking and other destructive activities. And what we've found is that as environmental crises have extended across the globe, that there is a growing understanding that we must fundamentally change the relationship between humankind and the natural world, and recognize the highest level of legal protection for nature that we have in the law. And that means the recognition of legal rights of nature. Furthermore, we find that communities, as they're finding in the United States and in countries around the globe, an increase in fracking, an increase in fossil fuel extraction, of course, an increase in the impacts of climate change. Last year, 2017, we assisted the first community in the United States, that's the city of Lafayette in the state of Colorado in the Rocky Mountains. We assisted Lafayette to ban fracking as a violation of, one, first, the human right to a healthy environment and a healthy climate, and second, the rights of nature to be healthy and thrive, including the rights of nature to a healthy climate. They called it there a climate bill of rights to prohibit fracking and fossil fuel development as a violation of the human right to a healthy environment and the rights of nature. Lastly, I wanted to finish by letting you know that we're also working, of course, outside of the United States in other countries, and partnering with people, with communities, with NGOs, and even governments to advance legal rights of nature frameworks. And this includes in the country of Nepal, where we've been working for a number of years to advance a rights of nature national constitutional amendment, specifically a right to a healthy climate for humans and nature. And this includes rights of the Himalayas to a healthy climate. Nepal is home to Mount Everest, and studies show that the Himalayas are experiencing the fastest rate of warming from climate change of any mountain range on Earth. By recognizing a constitutional amendment there, that is a constitutional rights of nature, including the rights of the Himalayas, intended to provide Nepal and the people of Nepal the ability to defend the rights of the Himalayas from climate change impacts from major polluters around the globe. I will end there and thank you very much for this opportunity, and I'm happy to take any questions. Thank you.
Thank you, Mari. Does the tribunal have any questions for Mari? I have a very simple one, Mari, based on the work that you've been doing. I mean, the nature of this PPT is looking at, does fracking violate human rights and earth rights? From your experience and the work of the communities you work with, do you think fracking violates the rights of humans in the natural world?
We absolutely believe fracking violates the rights of nature, the rights of human right to a healthy environment, the rights of the natural world. And furthermore, we see that by legalizing activities such as fracking and other fossil fuel extraction, it stands in the way of people and their communities, not only from protecting nature, but by putting in sustainable, earth-friendly energy systems in their place. It's impossible to have a sustainable energy system within your community if fracking is taking place. And therefore, we see it as a fundamental violation of the rights of nature, of the rights of humankind to a healthy environment, and as not a legal and practical barrier to establishing sustainable systems in its place.
Thank you, Mari.
Thank you.
Gil Beringer. Mari, I was wondering what has been the reaction in Colorado to what the city of Lafayette has done. Is there a challenge? And well, yeah, can you tell us a little bit about it?
Well, in Colorado, as in other places, the oil and gas industry, of course, is very powerful. We've seen communities in Colorado that have banned fracking or have put moratoria on fracking, have seen both the state of Colorado, that is the state government, along with the oil and gas industry, sue communities to overturn those laws. I know you spoke yesterday, the first day of the tribunal, regarding Mora County and John Olivas, former county commission chairman there, who we worked with Mora County, New Mexico, to assist them to put in place their ordinance, which banned fracking as a violation of the human right to a healthy environment and the rights of nature as well. And what we found in both New Mexico and Colorado, which are, of course, our neighboring states in the US, that you have industry and government partnering to stop communities from putting in these place protections against fracking, and successfully going into court and getting court rulings in which the courts are saying that state law preempts communities from being able to protect themselves, as we saw in Mora County. This has not happened yet with Lafayette, which I spoke about earlier, which established a climate bill of rights. But I can tell you what, in Mora County, which faced, as John Olivas, I think, explained, a challenge in federal court. And the US District Court, the federal court judge, Judge Browning, said in his ruling, which found that Mora County was preempted in banning fracking, he also wrote in his decision that Mora had, quote, a legitimate county interest in enacting the ordinance. That is, that he felt great sympathy for the community and said they had a legitimate interest in trying to protect against fracking, to try to protect the human health and the environment and nature from oil and gas extraction. But his hands were tied. That is, he found that state law preempted the community, and he said specifically that that's something that state government and the federal government and courts were going to have to reckon with in order for the people of Mora County to protect themselves. So I say that to say that we see this very much as the beginning of a movement. Michelle spoke in her opening about this being about building, really, we see this as standing on the shoulders of past people's movements who saw that government and laws were oppressive and unjust, and needed to have a fundamental shift in those laws in order to protect people, and in this case, to protect nature. And we see this as about building a movement to do so, which means confronting unjust laws and putting in place laws that establish what we need to see in the law, even when those laws may get challenged, because we know that we have to keep pushing that forward to ultimately establish in the United States, of course, at the state level and ultimately at the federal national level, these kinds of laws, including constitutional rights of nature. And in the United States, in places like Colorado, where Lafayette is, which established the Climate Bill of Rights at the local level, we've been working with people and communities and groups to advance state level constitutional amendments, which would begin to codify rights of nature protections at the state level. And we see it in the United States needing to build upward from there, including through this local lawmaking to the state level and to the national level.
Thanks. One other question, just to get it on the record. We've had a number of people, including in the previous session, a very strong position that fracking is inherently damaging and needs to be banned. You can't frack and expect nothing bad, no harms to happen. So I was just wondering what your recommendation is to the tribunal. Should we, are you asking us to recommend that it be banned? Some kind of moratorium or total ban, whatever.
Yes, I think the short answer is yes. I think it is inherently destructive, inherently violative of the human right to a healthy environment and the rights of nature.
And you say that on the basis of many years of working on this issue. It's not just an opinion. It's a thoughtful and reasoned response to what you have seen and read and understood.
Unfortunately, it comes from communities across the United States, as well as, of course, study upon study, which shows the environmental destruction that comes from fracking. But the many, many people and communities and even governments that we have worked with across the United States, which have seen that even upon the threat of a lawsuit from industry or even their own state or federal government, people in their communities and local government officials are moving forward to ban fracking as a violation of the human right to a healthy environment and the rights of nature, because they understand that it is inherently destructive and inherently violative of rights. And even with the threat of a legal challenge, they are needing to move this forward because they have no other way to protect themselves other than by taking this step at the local level to establish a legal ban, knowing that they could be threatened with a lawsuit, they could be threatened with bankruptcy at the municipal community level, but they see that they have absolutely no other choice under the law than to take that step.
And just to follow up, I hear from the evidence and the testimony and what I also know from my own experience and research, the real problem here is that the corporations are so powerful that they get away with ignoring the law, violating the law, so that simple law reform or trying to tighten up regulation and so forth cannot work. Would you agree with that?
Yes, and we didn't really have the time in the presentation to speak about it, but our work is broader than recognizing the rights of nature and banning activities such as fracking. We take a very systemic approach to protecting the natural world. And by that I mean is we absolutely recognize that so long as corporations have rights and protections which they can wield against people, against communities, and of course against nature, that we simply cannot protect the environment. So even if we prohibit fracking tomorrow around the globe, corporations will find another method to extract oil and gas and fossil fuels. And so therefore, we have to understand that the system itself is destructive to the natural world. It's not enough just to ban fracking or just to ban mining or other destructive activity. We have to fundamentally change the system of law. And that means in our communities, for example, in the United States, not only are we assisting them to recognize rights of people, communities, and nature, we're also then simultaneously removing corporate constitutional rights, corporate protections when they come into violation of people, communities, and nature. So essentially elevating the rights of people and nature over the rights that corporations have. Because without a fundamental shift in that system, without establishing that the rights of people and nature are prime, then we're unable to protect the environment. And so we worked with more than 30 plus communities in the United States to withdraw, to remove corporate constitutional rights when they will violate the human right to a healthy environment and the rights of nature. And without doing then you're kind of leaving out half of the equation by establishing rights, but without removing the rights and protections that corporations have of which they can override the rights that nature has.
Well, let me just follow up on that again. Sorry, this is very interesting and important, I think. And I like your approach, but I would say that I'm a little skeptical about using the law and concepts of rights and so forth to control corporations, given their power and not only regulatory capture, but governmental capture. And being a criminologist, I know that there's a lot of power that goes along with money, and that corporate bodies have gotten away with murder in the workplace, and on and on we could go on, because there are many things in this discussion about fracking that reminds one of the tobacco companies, big pharma, and the others who know things. Asbestos here in Australia, we had a shocking example of that with Hardy's. They know and they do. So maybe we should be talking about getting rid of corporations in some way.
Well,
moving towards a cooperative community rather than one dominated by corporations.
Well, I think to that point specifically, when we work with communities, they understand that it's not enough to prohibit fracking, for example, without looking at another means to create sustainable energy systems. And the idea of cooperatively or community-owned systems to provide energy or farming or water, of course, is increasingly being discussed, and methods to implement. Because I think you're quite right, we can't just eliminate the need of energy. We need to find a way to do it sustainably and locally in a humane system. And I guess I would just say one other thing, if I may, that sort of is a broader idea, which is, I understand that the tribunal is very focused on fracking, which of course is taking place now around the globe. But we also think it's critically important that we don't, I guess, divide ourselves by certain kinds of environmental destruction or environmental practice. And by that I mean, of course, you mentioned big pharma. There's big oil, there's big gas, there's big ag or big food. There's all sorts of ways that corporations and industry have divided us as those who are seeking to protect the environment by a particular practice, environmentally destructive practice such as fracking. So, which is to say that I think that we need to take a very systemic view of how we treat the natural world. So it's, in the communities that we work, it's very often that they're trying to stop a particular imminent threat such as fracking. And so of course that's what they're focused on prohibiting as they establish rights of nature. But they're not simply trying to protect the natural world from fracking. They're trying to protect it on the whole. And therefore activities such as fracking, but also corporate agriculture, pesticide spraying, and other activities, communities and people who are advancing rights of nature in other parts of the world at different levels of government, they're doing it on a broad spectrum. That is to protect ecosystems, to establish the rights of ecosystems, the rights of natural communities across the board, not just to stop fracking, not just to stop corporate agriculture and other kinds of activities, recognizing that it's going to take a fundamental systems change in how we treat the natural world. And I think it creates difficulties with us within the activist or advocacy world trying to protect the environment, and when we find ourselves divided by these different practices. And therefore, we think we need a systems-based approach not only to protecting the natural world, but in how we conduct our own advocacy to do so.
Thanks, that's really important.
Thank you, Mari. I'm aware of time and our time allotment, so we might move on, but I really can't thank Mari enough for elaborating on the approach that they've been using, the work they've been doing, and the tragic consequences they see in communities of the impacts of fracking. And I guess I'd also like to validate the approach SELDEF use and have shared with us and taught us about, which is this local lawmaking approach to blanket recognition of the rights of communities and the rights of nature to indeed challenge all environmental hazards and threats, rather than be breaking them off into little bite-sized chunks. So Mari, Margul, you're very welcome to stay on this session with us, but thank you so much for your time. We'll now move on. Is that okay?
Thanks, Michelle. Thanks, everyone.
Thank you, Mari. So thanks, everyone, for continuing to be with us. In our next piece of video material, we're now going to hear from scientist Dr. Damien Maher from the Southern Cross University, based in northern New South Wales in Australia. Damien has done extensive research, particularly focusing on the gas fields in Queensland. I apologise for not having a map, but for those who are not familiar with Queensland, It's the big pointy bit at the top of Australia on the right-hand side. And the Surat Basin is in the middle of that big pointy bit, the top of Australia on the right-hand side. I'm now going to turn to my trusted colleague, Lisa Mead, to show the video. I interviewed Damien Maher last week and asked him about a couple of specific issues. We were particularly interested in his research looking at fugitive methane emissions. So basically the gases that leak up through the coal seam wells in Queensland, and trying to understand what are the threats from those methane gas emissions, the bits that leak through water and soil, its contribution to greenhouse gas emissions, and its threat to water and life around it. So Lisa, are you able to show that video for us?
Yep.
Thank you. It's about 15 minutes, everyone.
My name is Damien Maher. I'm an associate professor at Southern Cross University in Australia, and I work in the School of Environment, Science and Engineering.
Thank you, Damien. Before we talk in detail about the research that you've undertaken in relation to fugitive emissions and unconventional gas extraction, can you please give us an overview of how unconventional gas extraction contributes to climate change and why it's important to measure fugitive emissions?
So when we're talking about unconventional gas, we're talking about extracting methane. And methane is far more potent as a greenhouse gas than carbon dioxide. So if we have a look at the global warming potential of methane, it's about 86 times more potent over a 20-year time frame, and about 34 times more potent than carbon dioxide over a 100-year time frame. So essentially, if we have leaks of that methane during the mining process or the transportation process, then we need to account for that in terms of the effect on climate change, because we're increasing the atmospheric concentration of methane.
Thank you, Damien. So now can you please turn to your own research, and can you give us an overview of the research that you have carried out within Southern Cross University regarding fugitive greenhouse gas emissions from unconventional oil and gas extraction? We're quite interested in knowing the nature of the research, your focus areas and the geographical location, and what the key research parameters and questions were.
Okay, so the research that we've undertaken is primarily in the Surat Basin in central Queensland. The research questions that we're interested in were, do we have higher methane concentrations in the atmosphere, in the gas field, as opposed to outside of those gas fields? We've also done work looking at groundwater, surface water connectivity, and how coal seam gas development may influence that in the Clarence Morton Basin, which is also in New South Wales. So some of the research questions that we were really interested in, is there a distinct enrichment of methane in the atmosphere in those coal seam gas fields compared to nearby areas? If so, what are the potential pathways of those emissions? So is it coming just from the wells and the infrastructure, or are there other pathways for that methane to enter the atmosphere? We're also interested in whether or not we can use stable isotopes, which are essentially a chemical fingerprint of that methane, to determine if it's coming from the coal seam or if it's coming from some other pathways. So for the groundwater, surface water connectivity work we did, we're really interested in undertaking baseline studies to understand how important groundwater is in surface water and river hydrology and ecology.
Thank you, Damien. So particularly in terms of the fugitive emissions, can you talk to us a bit about the findings of your research so far?
Yes, so essentially what we found was much higher concentrations of methane in the gas field in the Surat Basin than outside of the gas fields. So we used instrumentation that allowed us to also measure the stable isotope ratio of those methane emissions, and we compared that to the stable isotope ratio, or the chemical fingerprint of the methane that's found within the coal seams of the area, and we actually found that it matched as well. So not only do we have higher concentrations in the gas field, but that methane is coming from the coal seam. So there can be obviously other potential sources of methane. So in that area there are large cattle feedlots and wetlands and so on, but we were able to kind of narrow it down to emissions coming from the coal seam. So another bit of work that we were interested in was kind of characterising the pathways for that methane to enter the atmosphere. And to do that, we measured radon concentrations in the atmosphere. So radon is a radioactive gas that's formed in the soils. So our hypothesis was that, you know, some of these gases may be coming up through the soils rather than via the infrastructure. And through our radon measurements, we actually found a very strong relationship between radon concentrations and the number of nearby wells. So it appears that this methane is not only linking through or leaking through the infrastructure, but also potentially coming up through the soils as well.
Thank you, Damien. So I guess to recap, for a layperson, for someone who's not a scientist, what you're telling us is that your research has demonstrated a process for identifying specific types of methane coming from specific sites. You can actually tell through your process that it's coming from the gas fields.
Yes, so we can use isotope fingerprinting techniques to differentiate the different potential sources. So through doing that, we can say that the dominant source of methane that was in the atmosphere came from the coal seam originally.
Thank you, that's very helpful. And another question, I guess, from a layperson's point of view, a non-scientific point of view, are you able to explain or quantify to what extent or to how much of the methane that's coming out of the soil is different to what would be in the background atmosphere? Like, what kind of volume are we looking at?
An excellent question, and certainly our research, we couldn't quantify that yet, and that's an ongoing area of research that we're looking at, to kind of take those initial measurements where we can see that there are leaks and to actually quantify how large those leaks are. So we're certainly still working on that, but I couldn't give an answer to you now.
Okay, well, perhaps something that would help, particularly as we have an international audience. Can you estimate how many wells we have in Queensland at the moment, or in Australia?
Look, as of about 2014, 2015, I believe there were about 6,000 or 7,000 wells, coal seam gas wells. But yeah, since then I'm not sure, but certainly the number of wells has been expanding exponentially since the early 2000s.
Yes, and so if every well has been proven to be leaking methane, we already have 7,000 to 10,000 of them in certain regions of Australia, and it's only growing, then obviously the total amount of methane, the fugitive emissions, are increasing.
Yes, and look, it's quite possibly the case that not all of the wells are leaking, but you know there certainly hasn't been analysis on all the wells. But what we can say is that there are leaks and widespread leaks occurring in these gas fields. So other research in the US, for example, has found that a lot of the leaks are coming from a smaller number of the wells, but you know, I don't think we're at a position here in Australia to kind of make those judgments yet.
Thank you, Damien. So do you believe that given these leakages, these impacts on climate change, these leaks of methane into the atmosphere, can they be mitigated or completely eliminated from the industrial practices of the gas fields?
My personal opinion is that you cannot stop all the leaks. There will always be leaks. No matter how good the management is, there will always be leaks. So all that can be done is that things are monitored and measured, and you know those leaks are addressed as soon as they're kind of found. I guess one thing that our research suggests may be happening are these methane leaks through the soils. So this could be due to changes in the geological structure through fracking and so on, that actually increases the connectivity of the coal seams and the atmosphere. So we may have created cracks and fissures that actually allow that gas to flow from the coal seam into the atmosphere. Now these leaks are far more difficult to deal with, and there's an example in the Surat Basin where we've done work of large methane seeps in the Condamine River, for example. Now, whether those leaks are natural or due to industrial development in the area, we may never know, because we didn't undertake baseline studies in the area prior to the industry going ahead. But if these large seeps are due to dewatering of the coal seam and fracking and so on, then they may be occurring elsewhere. And trying to seal up these diffuse leaks is far more difficult than fixing up a leaking pipeline or well, for example. So, my opinion is we can't stop all the leaks, and it takes a lot of monitoring and good management to minimise those leaks.
Thank you. And in fact, picking up on the absence of baseline information, would you say that this area is under-researched in Australia?
Look, certainly something that myself and my colleagues have been calling for is these extensive baseline studies prior to development of an industry in an area. And certainly historically they haven't been done extensively enough. And, you know, it's something that you really have to do to assess any changes. So I would certainly say that, you know, we need to be doing it, and it's probably not being done as well as it should be.
Yes, thank you, Damien. It's obviously one of the many concerns is that the industry is under-researched and we do not understand its full impacts in many places. So our final question is really for your opinion, based on the work and the places you've been and the impacts you've seen. In your opinion, given our current understanding and the current practices on the gas fields, do you think fracking and unconventional oil and gas extraction should be banned?
Well, I'll say it's not up to me to make those decisions, but certainly in particular areas, say where we have groundwater dependent ecosystems, very valuable ecosystems that may be affected by fracking and unconventional gas extraction, then yeah, certainly in some areas it should be banned. But whole industry-wide ban. That's not for me to kind of make a decision on. I would say that certainly we need to be assessing and accounting for the fugitive emissions when we're kind of weighing up unconventional gas in terms of it being a bridging fuel. So a lot of the push towards using unconventional gas as an energy resource has been based on the fact that at the end point of combustion, we produce less greenhouse gases than if we were using coal or other fossil fuels. However, if we start adding on the global warming potential and the leaks of methane on top of those end point of combustion greenhouse gas emissions, then we start to see a bit of a levelling of the playing field between other fossil fuels and gas. So we need to kind of look at the big picture scenario here when we talk about using unconventional gas as a bridging fuel.
Absolutely. Okay, Damien, thank you so much for your time, and we'll leave it there for now.
Okay, thank you.
Thank you. Okay, thank you very much, Lisa, for showing that video interview of Damien Ma. I'm now going to return to sharing the screen. Just bear with me while I fiddle with the technology. And we'll move on to our next part of our presentation. Oh, forgive me, folks, what I had it set up. Okay, that was just a segue from the comments that Mari was making about the natural world not being property, and the fact that around the world, communities like the Australian Earth Laws Alliance community and others are hosting their own rights of nature tribunals. We'll be holding a rights of nature tribunal in October on Saturday the 27th in Australia. It'll be looking at a range of issues to do with big ag and the impacts on the Great Barrier Reef and forests. I'm now very pleased to hand it over to Lisa. She's going to give an overview of some of the research that is connected to our submission that looks at the violation of the rights of nature due to earthquakes and seismic activity that is believed to be caused by unconventional oil and gas extraction. So Lisa, I'll move the slides for you. That might make it easier, but if you'd like to begin.
So yes, another very dramatic and immediate threat from unconventional oil and gas extraction to the living world is the industry's causation of earthquakes and seismic activity. And these are often caused by the wastewater that remains after drilling activities being injected back underground at high pressure. Now this wastewater may contain chemicals, many unknown or untested chemicals, heavy metals and radioactive materials. So in Appendix 1 of our written submission, as well as in our main submission document, we've set out a non-exhaustive list of some of the seismic events that have occurred as a result of various kinds of unconventional oil and gas extraction. And just to give you several examples of the kind of harms to nature that we're talking about, this first example took place in 2011. There was a 5.3 magnitude earthquake in Colorado, which was ascribed to wastewater injection wells from coal bed methane production. And the research that was carried out in the Raton Basin of northern New Mexico and southern Colorado by Justin Rubenstein and his colleagues in 2014, which we've referenced in our Appendix 1, showed clear evidence that the earthquake sequence was induced by fluid injection from that coal bed methane process. So the abstract of their research stated that they investigated the ongoing seismicity in the Raton Basin and found that the deep injection of wastewater from the coal bed methane field was responsible for inducing the majority of the seismicity since 2001. Many lines of evidence indicated that this earthquake sequence was induced by wastewater injection. First, there was a marked increase in seismicity shortly after major fluid injection began in the Raton Basin in 1999. And from 1972 through July 2001, there was one earthquake of a magnitude greater than 4.0 in the Raton Basin, whereas 12 occurred between 2001 and 2013. And they said that the statistical likelihood that such a rate change would occur if earthquakes behaved randomly in time is just 3%. So they said, moreover, this rate change was limited to the area of the industrial activity and that earthquake rates had remained low in the surrounding area. And so secondly, that the vast majority of the seismicity was within 5 kilometers of the active disposal wells, and the seismicity was shallow, ranging in depth from 2 to 8 kilometers. And in our second example, I think that's the first one, actually. Yeah, no, just go to 2 more. There we go.
I'm so sorry.
That's okay. In 2006, mud began erupting from the ground in volcano-like fashion in an urban area of Java in Indonesia. And that was 2006. And as at 2015, so it was still flowing, this Lucy mud flow had caused almost 40,000 people to be displaced and nearly $3 billion in damages and disaster management. And a study in 2015 concluded that the likely cause was nearby gas drilling, which forced fluid into a clay layer via the open well. And I think there's a photograph, the next slide, oh no, back one. This was the first day it happened, so you can sort of see the area that just disastrous impact on that particular area. So, in our submission to the tribunal, we draw on the rights of nature set out in Article 2.1 of the Universal Declaration of the Rights of Mother Earth, and assert that the rights of the land and the subsurface are being violated by these activities, and in particular, the following specific rights are being violated: the right to well-being, the right to continue their vital cycles and processes free from human disruptions, the right to integral health, and the right to be free from contamination, pollution, and toxic or radioactive waste. And just to say, I think Cormac Cullinan touched on this yesterday, that the concept of integral health in the Declaration of the Rights of Mother Earth reminds us of the essential interrelatedness of every aspect of the Earth community, and that the health of the whole system affects the health of any aspect of or being within it, and vice versa. So this understanding is also reflected in Article 1 of the Universal Declaration, which states that each being is defined by its relationships as an integral part of Mother Earth. And in this case, it's clear that earthquakes and seismic activity disrupt the capacity of nature to provide a stable, safe place for life to exist, to thrive, and to flourish. Thank you.
Thank you, Lisa. Because of time, unless anyone has a pressing query, we might keep moving. All right, we'll keep moving. Thank you so much, Lisa. In a moment, we'll go to our final piece of video evidence. So we were very interested when we were putting together the arguments and case that unconventional oil and gas extraction violates the rights of nature, to understand why communities were banning or creating moratoria to stop fracking in their communities. So the next piece of video information is basically enabling us to learn from Scotland's approach to prohibiting gas fields in their communities, following the most extensive review of evidence undertaken. We will hear in a moment from Professor Andrew Watterson from the University of Stirling in Scotland, and Dr. Will Dynan, also from the University of Scotland. Professor Andrew Watterson is the head of the Occupational and Environmental Health Research Group and a member of the Centre for Public Health and Population Health Research at the University of Stirling in Scotland. So he works in the areas of risk assessment, risk management, risk regulation in energy and agricultural sectors. So his evidence is very important. Dr. Will Dynan is a lecturer in communication, media and culture at the University of Stirling, and he's published on various aspects of political and environmental communication and regulation. So I will unshare, and if Lisa, you could run this video, that would be terrific. Thank you.
Okay.
Watterson. I work at the University of Stirling in Scotland, and I'm in the Occupational Environmental Health Research Group, which functions within the Centre for Public Health and Population Health Research at the university.
I'm Will Dinan. I'm from the Faculty of Arts and Humanities in the Division of Communication, Media and Culture. I'm affiliated to the health centre that Andrew just mentioned.
Can you please briefly outline the research that you've carried out in relation to fracking and unconventional oil and gas extraction?
In the last 4 or 5 years, we've been looking at unconventional gas extraction that's been linked to various proposed projects and developments in Scotland relating to coal bed methane and also underground coal gasification. But our focus has been primarily on fracking. And in that context, we've got a range of interests, initially linked to looking at health impact assessments that have been done on fracking, both in England, but also further afield, to get an idea about what the hazards are, what the risks are.
Could you confirm the country, the research you were looking at?
American research, we looked at Canadian research, we looked at Australian research, we looked at some German research as well. So we cast our net fairly widely. Obviously fracking is going on in a limited number of countries, and the US is the major source of information, and that threw up quite a lot of paradoxical things for us, because the industry was constantly saying we've learned from the lessons of Pennsylvania and now things are better. And we were frequently reading reports about a whole series of problems still in Pennsylvania. But obviously you're looking at where the activity has gone on, although different countries might have different settings.
We also looked at, just very briefly, what we could find in terms of policy debate in places where they were considering fracking too. So we're just looking at where the kind of opinion was on this in different countries. So we summarised a little bit of that research as well.
And we're also interested in looking at the total picture surrounding fracking with regard to a health view of the life cycle analysis of fracking. So that means the materials that come in, what are the health implications, the technology, the machinery that's developed, what are the implications, the transport in and of materials, the removal of products and the removal of waste products at the end, decommissioning and so on. The total picture. You find that there are often life cycle analyses of the economic impacts of energy activities, but there isn't one for fracking, or at least not yet. And we were concerned that some of these impact assessments were limited, that they could be skewed towards industry rather than take full note of the position of communities, and that they might even reflect the view of government that had already prejudged the issue of fracking and effectively was engaged in gathering evidence to prove a particular policy option rather than making policy on the basis of the evidence. So we looked at scientific and governmental papers, we looked at toxicology and epidemiology papers, we looked at industry and regulatory practices. We were also concerned with possible implications for climate change and public health, mental health and well-being, and where the precautionary principle fitted into all of this.
Yes, I should just add to what Andrew said there. My interest in this comes from studying, I suppose, the policy processes and communication around this issue, and looking at how industry was seeking to secure consent for operating and for fracking. But also, I suppose, how scientific expertise and different forms of expertise were translated into the policy debate. So It was those kind of interests allied with what Andrew's laid out that kind of formed the basis for a series of articles and reports that we've published over the last few years.
Could you summarize the main findings of your studies?
Okay, so together we've done 3 peer-reviewed papers in scientific journals, and we've produced 2 reports. And we've also offered information to government and others. So our concern was about how the risks that related to the established hazards and some of the suspected hazards of fracking were dealt with. And to do that, we needed to look at a range of scientific literature, and as Will has said, also to look at some of the policy material to give us an idea of what was going on. So at the end of the day, we had 14 projects or papers that were looking at fracking and were providing information about both public health and related issues. And we looked at the processes that were used to create policy. And within those papers and reports, we looked at 10 key characteristics linked to public health. So that would include occupational health, it would include climate, it would include transport, it would include seismicity, it would link in with the economic benefits and disbenefits. And I think we'll all say something about the sort of broader elements about that. And we also looked at regulation and industry. And what we found was that firstly, Scotland was the only national assessment that had ever been done of fracking. So there'd been assessments in states in the US, there'd been some assessments made in provinces in Canada, there'd been some studies done in towns and small regions, but the only global national assessment of fracking had come out of Scotland. And Scotland also addressed all of the key areas that I've mentioned and brought them together in the context of engaging the public as well. So they had the findings, there was the evidence, they got a view from the scientific community, from regulators, and then they pushed it out to the public and communities. And in that sense, it was quite unique. And at the time it was done, it was the most extensive review of the literature, the most up-to-date review of the literature. Not perfect, and we'll perhaps say something about that a little bit later, but nevertheless the best thing that was on offer.
Yeah, I would just add to that. I mean, I think really 2 features stood out in terms of the depth and the detail of the Scottish case. One was the analysis of public health research and the public health impact strand. That was very, very detailed. And I think conducted in a way that allowed other research to make a serious evaluation of the work that had gone into underpinning the advice that was given to government. So that was one aspect that stood out, that led into the other, I think, really outstanding aspect in the sense of comparatively outstanding, which was that the public consultation element was very, very strong. Very few of the other integrated assessments we looked at had such an element of public engagement. And some of them had elements of it early in the process where they kind of consulted key stakeholders and then carried on. But the Scottish one, I suppose, is remarkable for its effort to consult those stakeholders early in the process and then return with this evidence to the public later on for a kind of a wider deliberation about what this all means, that then fed into policy making. Now, of course, policymakers weren't bound by this, but it certainly informed their thinking, and I think that was a real, I think a striking characteristic of the Scottish case.
Do you think that there were any things that you would have improved in the way they approached it? You say that it was outstanding in some ways.
I think that they can justify their conclusions, that there were big gaps in the evidence about potential effects, but there was also, from our point of view, evidence of significant problems in the literature. And not all of that literature was necessarily, that was available, was necessarily covered at the time. So at the time and since, we've seen more evidence about neurological effects, about reproductive effects, about developmental effects, about carcinogenicity and possible exposures, about mental health and well-being damage. All of those things have come out, and perhaps could have been even stronger in the report. I think we were concerned that there was probably an underplaying of the mental health and well-being impacts, both of proposals to frack as well as fracking. And we also had some concerns about probably, I think we would say, the lack of rigour in terms of looking at how well regulators could deal with the problem and how good industry practice was. In a sense, some of these things were taken as given, but with all of those limits, nevertheless, the conclusion of those reports was that you couldn't make a strong case for fracking. And linked in with the things that Will's mentioned in terms of the public engagement, which was huge. Nothing like it has occurred anywhere else on the globe. I think that underpinned the decision that the Scottish Government took, the policy decision, not to pursue fracking.
I think it's kind of striking when you look at it in terms of what this debate is really about, is that there was not really a dedicated environmental impact assessment. So you had a really striking and quite detailed, we can come into some of the minutiae of that later on, but it was still, as Andrew says, globally quite an impressive public health impact assessment. And for some reason, the Scottish Government decided not to have an environmental impact assessment. Now, they would argue that part of this was subsumed under an opinion that came from the Climate Commission about climate impacts and stuff, but there wasn't the depth in that approach that you saw in terms of public health. So I think that's quite striking.
And what poses the biggest health risks, either to humans or to animals?
I think there's probably international agreement about what the route's going to be. It's got to be, there will be air pollution. It's what level will the pollutants be there. The hazard is there. Nobody disagrees about that. It's what the risks will be, what the exposure will be. The same would be true of water. And we're not just talking about accidental spills there. We're talking about wastewater treatment and indeed the capacity, certainly within Europe, and this has been flagged by other researchers, the capacity to deal with frack water. So that would be an issue. And then there's the problem afterwards about to what extent we understand the geology. And bearing in mind, particularly the central belt of Scotland is a coal mining area with lots of seams and shafts. That could be a major issue, as indeed it could be within England. And then we've got the soil pollution issues. So I think there is, even in industry, there's a recognition that there are hazards. The argument is that the industry will be able to control soil, water, and air pollution. And it will never be at levels that create a problem. But that seems to ignore from what we have seen, and again, perhaps it was underplayed in some of the Scottish Government reports. It seems to ignore the issue of low-level exposures. And if people are focusing on parts per million or parts per billion, they're missing the picture. Because if we're looking at endocrine disruptors and some of the other effects, we're looking at parts per trillion having an effect. So the argument, well, there'll only be very low exposure, it won't be a problem, simply isn't the case. And what's perfectly clear from the work of environmental scientists in the UK, highly respected ones, is the view that if we pursue this as an energy source, then the climate impacts are going to be considerable, and those impacts will adversely affect public health. So I think our focus has always been public health, and the big global picture will come back to Scotland. People in Scotland won't escape the implications of that, the public health implications of climate change. So the big picture is that it's a no-no. There are alternatives that are likely to be, certainly in the middle term, again, leading to greater prosperity, more tourism, the green image of Scotland and so on. All of these things would be damaged by having hundreds or thousands of wells. And there's the threat to livelihood is a public health issue. The benefits that economic benefits that have been identified seem to be very, very small. And it's not a sustainable approach, even in terms of the industry, for more than a decade or two.
I'd echo that to just his last point there about the economic analysis. I think that even the best projections that were estimated on the economic impact, long-term impact of fracking in Scotland were still disappointingly low, in fact vanishingly small, I would have thought. That it really made it difficult for the Scottish government to make a case based on kind of the benefit in terms of economics. So I think all the issues that Andrew has raised there around the difficulties, and it would force government into a precautionary approach. And I think what's really striking in terms of the Scottish posture on this compared to the UK posture is that the Scottish government have kind of adopted, they don't use that language precisely, but there's definitely precaution in how policymakers are proceeding with this, whereas if you compare it to Westminster, it's a kind of a gung-ho dash for gas, and they're doing it in the face of quite mounting public opposition, and as Andrew's pointed out, actually a huge amount of questions and evidence coming to the fore that really questions the sense of this in terms of sustainability, economics, and kind of the local impacts.
That's it. It's the end of the video. Do we have Michelle there? Hi.
Yes, I'm still here. Thank you, Lisa. Thank you very much for showing that video material. I'll just bring up our slides again so that we can move into our closing statements. Okay, so really want to thank Lisa for having that discussion with the researchers in Scotland. I think it's very important that we learn about all this analysis and the reasoning they used to actually impose a moratorium or a ban on fracking. It's a very valuable report as well for the rest of us. So we're very pleased to be coming to the end of basically the 4 hours of discussion about earth rights within the context of this Permanent Peoples Tribunal on the impacts of fracking. What I would like to do is give a brief summary of the overall case that we've presented to the tribunal, and then I'll hand over to Lisa to talk about what we would request the tribunal consider and recommend. So in a very brief overview of the session today, we've heard from Mari Margil at CELDEF about the work they've been doing in the United States to not just activate bans on specific areas related to fracking, but to actually look at transforming the system by using community rights and nature's rights to impose, impose a local law that actually bans those activities, but also protects the rights of nature. We've also heard about evidence linking to greenhouse gas emissions and other aspects, which I'll talk about. But in summary, by drawing on the Universal Declaration for the Rights of Mother Earth, the UDRME, we argue that nature's rights are being violated by unconventional gas and oil extraction in four significant areas. It violates the rights of rivers, aquifers, and waterways, and by linking specifically to the wording of the UDRME, we believe fracking violates waterways and rivers in that it violates their right to continue their vital cycles and processes free from human disruptions, violates the right to integral health, which Lisa spoke about before as a way of explaining or articulating the interconnectedness and the vital interconnectedness for good ecological health. And it also violates the rights of water systems to be free from contamination, pollution, toxic or radioactive waste. We heard from Gavin Mudd in Australia, where the Condamine River has now quite famously been set alight because it had so much gas and methane bubbling up into the waterways, this in an extremely arid area. We also heard that sometimes when the fracking and coal seam gas processes take place, no one can guarantee that they can repair the aquifers, the actual structural damage to the rocks and the soil and the earth as they break through. And the interconnectivity of the waterways mean that when you violate the rights of a river in one place, that water flows and interconnects to groundwater in other places. So we strongly believe fracking absolutely violates the rights of rivers, aquifers, and all things liquid in the living world. We also just today heard from Damien Marr about the research that's been undertaken to look at fugitive emissions from coal seam gas in Australia, but research around the world shows that methane, which is the most damaging greenhouse gas emission, is leaking from coal seam gas and other forms of fracking. I think the thing that was perhaps most scary about Damien's evidence is that they've got a very specific process for proving that methane emissions are coming from the industrial gas processes. It's not background in the background of nature. There is an absence of information. There are no baseline studies undertaken about what's going on in the atmosphere or many other aspects of Earth before these coal seam gas and other gas fields are constructed. We cannot at the moment quantify the volume of methane that is entering the atmosphere. I find this particularly worrying, that scientists have been continually stating that they can prove methane is coming out. They don't know how much. And if we've got 7,000 to 10,000 gas wells in Australia, that's tiny in proportion to what's in the US. Therefore, the greenhouse impacts of fracking and unconventional oil and gas exploration is absolutely without doubt, the extent to which we don't even understand. This is a horrific violation of global efforts to reduce greenhouse gas emissions. And it's also a violation of the rights of the climate system that has evolved over billions of years to provide life, to have a right to integral health, to be free from contamination, and to support life. The third and second last area is the violation of the rights of land and subsurface. Again, in today's session, Lisa Mead gave a good overview of some of the research presented in our submission that indicates fracking and the violence of pushing down through the land has created seismic activities, earthquakes, and some of those really devastating mud pools and mudslides in other places. The evidence that's emerging around the world of the violation of the land and subsurface, definitely from the point of view of the UDRME, violates the right to well-being, the right for the land to be a place to support Mother Earth, the right to continue vital cycles, integral health, and again, to be free from contamination, pollution, or radioactive and toxic waste. Finally, we saw devastating information from Michelle Bamberger about the impact of fracking in the US on animals. We heard from David Paul about, again, the absence of information and significant research that can prove that there is no harm from gas wells and others to natural systems. The impacts on water alone can have a devastating impact on plants and animals. So we would argue or put to the tribunal that unconventional oil and gas extraction absolutely violates the rights of animals and plants in terms of their right to well-being, the right to a place, somewhere safe to live, to play their role in the ongoing evolutionary functioning of the earth, a right to continue their vital cycles, and to be free from contamination. About the only other thing I wanted to mention was that throughout the evidence, particularly from the scientists in our session, we have seen not only the violation of the natural systems, but really some very fundamental violations of existing international law, including the precautionary principle. We have seen a plethora of evidence that shows no baseline studies, no real understanding of the impact of these industries, and in the face of a principle as simple as a precautionary principle, if we are uncertain as to the extent of damage, but we know that there could be damage, we simply shouldn't go ahead. When you combine the precautionary principle with some of the information that Damien Ma suggested at the end of his testimony, which is, in light of the methane emissions alone, the argument used by the industry to support the expansion of fracking, that fracking and gas is a bridging fuel, I think have been actually shown to be erroneous. It cannot be a bridging fuel if it's actually leaking methane into climate change processes. And in fact, as Mari Margul said, by having these industries in place, we are preventing our communities and societies from shifting to clean energy and clean fuel. So with that, I'm going to hand over to Lisa. We believe that the rights of nature are extremely violated. We feel that the UDRME, if it was the basis today of current and existing law globally and in Australia, we would have legal grounds to ban fracking and coal seam gas. I'd now like to hand over to Lisa to talk about what we would like to recommend to the tribunal.
Thank you, Michelle. can I shift down to, can you go down to our requests to the tribunal?
Sure.
Sorry about that, yeah. So we ask the esteemed judges of the tribunal to acknowledge and recognize nature's rights as fundamental to the health of nature, of which humans are a part, and of ecosystems. And we ask the tribunal to declare that continued exploitation of unconventional oil and gas is entirely indefensible from the perspective of climate change. And we ask the tribunal to condemn the devastating impacts of unconventional oil and gas extraction on the natural world in all jurisdictions where it takes place. And we lastly ask the tribunal to call for a cessation of all unconventional oil and gas immediately, and for a worldwide ban on the industry for all the reasons we've stated. And the next slide. So furthermore, in terms of restorative measures, which is a fundamental principle of Earth jurisprudence, we ask the tribunal to call for full and prompt restoration for the violation of the rights recognized in the Declaration of the Rights of Mother Earth caused by human activities. And we also ask the tribunal to order that governments and corporations in all affected jurisdictions create a special fund which communities can use to, wherever possible, restore the natural world to the condition that it was in before the industry's actions took place, where this is possible. And in closing, just a couple of final thoughts. Of course, we are nature. We humans are part of nature. And in this, I'm reminded of the street slogan that emerged during the Paris climate change talks, which said, "We are not fighting for nature. We are nature defending itself." And if we look beyond ourselves, beyond the planet, to the wider picture, we see that we need to think systemically, because everything we do needs to operate within the limits of the system we are in. So, of course, our economic system is just a subsystem of a much larger planetary system. And we simply cannot keep behaving as if we can have endless growth on a finite planet. And of course, the dash for gas and oil in so many places at the moment is part of this ignorant dinosaur thinking, with all due respect to dinosaurs. So really, it comes down to us recognizing that nature has non-negotiable constraints that must be respected and complied with. And of course, we ignore this at our continuing peril. So I would like to thank the judges who've been present today, who've stayed with us, and also for the PPT for giving us the chance to present these arguments and ideas on behalf of nature, to allow us to speak on behalf of nature. So thank you also to our witnesses, our fellow lawyers, to Phoebe and Cassie, who helped us put our evidence together. They were amazing, and really to everyone who's been part of this. Thank you and good night.
Yes, or in my case, good morning. So, and if, as closing remarks, if the tribunal would like to explore any of the documentation or the evidence we've presented in our submission, please email us at any time. We'd be very happy to provide more data or details. But on that, I guess we'll close. Is that right?
But there's time for questions.
Just one comes to mind. If you talked about a special fund, did you have any particular targets from which or from whom you wanted to attract the money or extract the money?
I personally think that that's quite a complex issue, because some of the companies in Australia and the government liability would have to be kind of thought through. And particularly in the US, it's been an industry that has now incredibly extensive. So I think, quite frankly, if we were to succeed in some kind of ban, any company, anywhere that has been engaging in that industrial activity would be targeted to contribute.
Yes, I agree. Certainly shouldn't be the taxpayers.
Oh, definitely not.
I have a response to that. Something that I had hoped we'd be able to enter into the tribunal. Maybe this is a place to do it. Mary Wood teaches law at the University of Oregon, who initiated the whole idea of the public trust doctrine that led to our children's trust cases. You're familiar with her?
Yeah.
She has a new prospectus that directly addresses your suggestion there, Lisa, about she refers to the carbon majors, and that there are suits already underway against some corporations that, for billions of dollars for reparations. And her prospectus is put it together, and I heard her outline this at a law conference a couple months ago, and she's summarized it into a little 3 or 4 page prospectus that I would have liked to be part of the tribunal as one of the things that we could ask the tribunal judges to recommend. So,
is that available?
It's available, yeah, I'd be happy to enter it into the record.
I think we'd be happy to see it.
Okay,
Yeah.
Great.
And we can add it as an addendum to our submission as well. And I think she looks more broadly across fossil fuels, not just at fracking. So I think it would be an excellent suggestion. Thank you, Tom.
Right. That's right. And the whole focus of it is public trust, which she sees, and I kind of agree, as a human rights issue. And I'd be interested to hear your thoughts as to the public trust idea's notion, how that connects with rights of nature, if at all.
Well, it does, and I'll go first, but if Lisa would like to comment too. The public trust doctrine is particularly used in the US. It has limitations in other jurisdictions because it's either not historically used or there's no structure for it. So for many people in the US, they think it's like a generic legal thing. It's not. In Australia, it's very rarely engaged. From the point of view of rights of nature, if I was to be a purist, I would say that the public trust doctrine in the US and in the few other places that it engages with, it's predominantly focused on the government as the holder of the trust of the people.
Right.
So it's actually very, very powerful and very useful. But if, in fact, the government is the holder of the so-called property rights over nature, the rights of nature movement, in a way, challenges that notion and looks for more ecologically democratic and guardianship-based structures to support the rights of nature. So that's a very simple, as you can imagine, simplified analysis.
Yeah, so that almost...
Very powerful, but if you're to be a purist, it's not the most effective way to change the system.
If you were to try to make them compatible in some way, do you think that's even possible? Because
yes, of course.
In some ways, the public trust doctrine is basically that governments are the holders of a trust for future generations, that they will be able to have the same resources that this generation has. So it kind of looks at public lands as stuff, things to be held in trust for future humans. So it seems like it would be hard to fit them together, but if there was some way to make all three of those things, human, rights of nature, and public trust, fit together, that could be a powerful...
Well, I agree, but I'd also suggest that you don't need public trust to create powerful mechanisms to support the natural world. For example, what's happened with the Whanganui River is nothing to do with the public trust. The Maori people, who see their worldview as deeply connected to the spirit and material values of that river, are now guardians in conjunction with the Crown. There's no need for public trust because, but at the end of the day, a trust structure created in Western legal concepts was always about creating a beneficiary and a distance between the people managing it and the folks who would benefit from it. So we can definitely create all manner of frameworks to support better custodianship of the natural world and human rights. I think public trust has a lot to offer, and in the same way that we see legal personhood as, in some ways, an easy step for Western legal systems to comprehend and understand, Act, public trust mechanisms are similar. They can be a system that can move away from the excessive privatization of everything and hold things in a public trust. However, I would suggest that in this day and age, we can't rely on governments to be the public trust holders because they are so often influenced, and I'm being polite here, by corporate interests. So community land trusts, indigenous structures of custodial responsibility enshrined in modern legal systems are actually what's most exciting in the rights of nature space, I would suggest.
Thank you.
Thank you. I do actually have to run. I'm so sorry. We've got a very tight time frame this week for my activities, but if anyone's got one more quick question, I'm happy to take it, or I can jump off with great humility and gratitude and leave you with Lisa.
Other questions? Okay, Shelley's probably going to come back on here in a second and say.
Okay. Well, I think we've all done marvelously. I'm very impressed that it's 8:30 my time and we're finished.
I know. You even started 3 or 4 minutes late, I think.
I think it was like 10 minutes late.
Yeah.